Welcome to a fresh episode of Legal Wrangle, where we will track major judicial developments that have taken place in the last few weeks in the realm of international taxation. For this, we have selected three important cases. The first one discusses the taxability of subscription cost in the hands of foreign entity for providing access to online database. The second one discusses the cumulative counting of stay of employees of foreign company in India for the purpose of establishing its permanent establishment. And the third one discusses the taxability of individual shares received by non-resident members of a consortium in execution of projects undertaken in India. Our first case in this episode revolves around the taxability with regard to subscription cost in the hands of foreign entity for providing access to its online journal software to customers worldwide. Let's understand what exactly happened in this case.
The SSE in the present case maintains an online database pertaining to chemical information which includes articles on chemistry topic, substances data and inputs on preparation as experimentally validated. Now, it was the claim of the SSE that subscription fee received from the customers in India for providing access to his online database was neither in the nature of royalty nor FTS, as there was no PE in India. The IT department, however, opined that such database was in the nature of literary work and akin to a very well-equipped library of relevant information, along with an expert librarian which on demand would provide instant required information. Hence, the access to database amounted to transfer of right to use a copyright, and its subscription cost would be taxable as royalty.
Now let's see what the tribunal had finally decided. Payment received overseas for transfer of copyrighted database in a journal would not amount to royalty if the exclusive right and ownership over intellectual property relating to the product is retained by the transferor. Subscription fee charged by the journal for providing access of database to its subscribers would not amount to fee for technical services. Granting access to subscribers of the online database through various search engines provided through internet connection does not involve human intervention, and hence the cost of such access would not amount to FTS. Moving to our second case, the tribunal was approached to decide as to whether the period of stay of employees of foreign entity in India on a particular day has to be taken cumulatively for the purpose of proving existence of permanent establishment. Let's understand what exactly happened in this case.
The SSE in the present case is a non-resident entity, and it had been appointed as a legal advisor for some of the projects in India. Now, it was a case of SSE that the fees received by it in connection with rendering of legal consultancy services was not chargeable to tax since it had no branch office or PE in India. The AO, however, appointed that the personnel of SSE had rendered services in India for more than 90 days and hence it would constitute a PE. Resultantly, the legal consultancy fees were brought to tax in India. The SSE's contention that during the period of vacation, the concerned employees had not rendered any services to the SSE also came to be rejected, and it was held by the department that the activities in the nature of furnishing of services by an enterprise through its employees were to be seen as employee-wise and aggregated.
Now let's see what the tribunal had finally decided. The stay of employees of foreign entity in India on a particular day has to be taken cumulatively, and hence multiple counting of employee in a single day is impermissible under the provisions of the Indo-UK Tax Treaty. If the employees or other personnel of the foreign entity have stayed in India for a period exceeding 90 days in any 12-month period, then it will constitute a PE. If there is no PE of foreign entity in India during the relevant AY, then fees received by such entity from legal consultancy services rendered in India is not taxable in India. Now let's move to our last case, where the individual shares received by foreign members of consortium in execution of projects undertaken in India was brought to tax as royalty in their hands. Let's see exactly what happened in this case.
The SSE company in the present case was represented by liaison office which assisted in identifying the business potential in India. In addition, it also had a branch office for rendering technical consultancy services. Therefore, While filing return, the SSE bifurcated its income into royalty income by HO and FTS by branch office. During the relevant year under consideration, the SSE had participated in various water supply and pipeline projects and offered to tax its royalty income at 10% on gross basis. On the other hand, the branch office income from such pipeline projects was shown as technical service fee. Now, the IT department was of the view that such receipt should be treated as royalty income, whereas the SSE's bone of contention was that it should be treated as business profit.
Now let's see what the tribunal had finally decided. Individual shares received in execution of projects undertaken in India cannot be taxed as royalty in the hands of foreign resident entities who are member of consortium, as it amounts to payment made to self. In absence of transfer of any technical know-how, the revenue in hands of non-resident entity cannot be bifurcated as royalty or FTS. If entire payment received by the non-resident entity during the year in consideration is attributable to its PE in India, then the same has to be taxed as business profits in its hands. With this, we wrap up this episode of Legal Wrangle. Thank you for watching. Goodbye.